Good morning. This is the Thursday, July 9th meeting of the Assembly Judiciary Committee. I'm Mike Fewer. I'm the chair of the committee. A few announcements at the outset. First, as is always the rule in this committee, there will be two witnesses on each side, each of whom is entitled to speak for 2 minutes. Others who wish to speak in support or opposition will simply identify themselves by name and any affiliation they wish to provide. There'll be 3 members of this committee sitting in today for the first time. We have Mr. Chesborough, who will be filling in for Mr. Jones. Mr. Delatorre will be filling in for Mr. Krikorian. And Mr. Nilo will be filling in for Mr. Nielsen. The other item I wanted to mention is that item number 4, SB 367 by Senator Negrete McLeod, is going to proceed on consent. With that, we have perhaps the most patient member of the legislature, Ms. Woke, who has been here awaiting. Oh, been here? Yes, that's right. We have a special deal. It's like if you stay overnight, you get to stay another night for free. So we have Ms. Woke here on item number 6, SB 660. Ms. Woke.
Thank you, Mr. Chair and members. First of all, I want to thank the chair for his assistance, and especially I want to thank the consultant, Mr. Tom Clark, for what I thought was an excellent analysis. Thank you for that, and for his assistance during this process. SB 660 addresses the growing concerns around the sale of reverse mortgages to seniors. The bill would impose an explicit duty of honesty, good faith, and fair dealing on those involved in the recommendation and sale of reverse mortgages. Reverse mortgages are loans that allow senior homeowners to convert a portion of their home equity into cash. They're complex and expensive and have potentially devastating consequences. Yet they're marketed with impunity to thousands of seniors in California, for whom they may or may not be suitable. The honesty, good faith, and fair dealing standard already exists implicitly in common law, and bankers must abide by it when participating in contracts. The legislature has made the standard explicit in other instances involving the sale of financial instruments to seniors, most notably in the sale of insurance products, where honesty, good faith, and fair dealing has been the standard for sale to seniors for 20 years. I have worked continuously with the opposition, taking substantial amendments through the Senate Banking and Judiciary Committees and the Assembly Banking Committee, and now in the Judiciary. And each time the argument has changed. We have tried to meet their concerns, but at this point we have reached an impasse with the bankers. They are asking for amendments to address at this point what I believe is a phantom issue, and there is no proof that it exists. This bill imposes the same standard on the banking community that the insurance industry has abided by for 20 years when selling insurance products to seniors. It is in numerous other code sections and defined in case law. There's nothing ambiguous about it. I would note that in the 20 years that the insurance industry has lived with this standard, there's no evidence of frivolous lawsuits as the bankers fear. Coupled with a skyrocketing number of reverse mortgages being issued nationwide, the media reports that indicate the subprime lenders are moving into this area, the recent federal GAO report on reverse mortgages describing the product as complex and costly and the population it serves as extremely vulnerable, and the evidence on the list of seniors suffering from the negative effects of loans, all this makes it seem to me reasonable and appropriate and essential that we heighten the standard of required behavior in order to provide seniors with good information and protect them from those who might take advantage of them. I do accept, Mr. Chair, the technical author's amendment involving the word solely, and again, I thank you and your staff for helping with this bill.
Thank you very much, Ms. Woke.
I ask for your aye vote.
Before your witnesses have an opportunity to testify, we have now a quorum. Please call the roll.
Fear.
Here.
Tran.
Here.
Brownlee. Evans. Chesbrough. Knight. De La Torre. Liu. Monning.
Here.
Nilo.
Here.
And again, I'd like to welcome Mr. Nilo and Mr. Chesborough. Ms. Woke, your witnesses, please.
Thank you very much. I'm Prescott Cole, Senior Staff Attorney with Cantor, California Advocates for Nursing Home Reform. And as a sponsor of SB 660, Cantor urges all members to vote for this very important consumer protection bill. If enacted, this bill will assist many seniors to avoid the devastating effects of an unsuitable reverse mortgage loan. In a speech about reverse mortgages to bankers, John Dugan, controller of the currency, recently warned that seniors may fall victim to marketing pitches and investment schemes and be unaware of the high-cost structures of these very complicated financial instruments. And in fact, last week the GAO issued a report about some misleading and aggressive sales tactics of these reverse mortgages. SB 660 would clearly state that brokers and lenders have a duty of honesty, good faith, and fair dealing with potential customers. Currently, there's little protection for these customers and virtually no consumer remedies. We believe that SB 660's call for the honesty, good faith, and fair dealing duty is very, very necessary. And we believe that the opponents of SB 660 are mistaken in their belief that the standard is too vague. SB 660 offers a reasonable approach to protect seniors from becoming involved with unsuitable reverse mortgage loans that may have a devastating financial consequence on the senior borrowers and ultimately to the state of California, in that when the seniors run out of money, when they run out of equity, they're going to be stranded in their homes. And what's going to happen to them after that? They will not be able to afford to go into an assisted living facility. Already we've had complaints. We've heard that individuals who are on waiting lists to get into assisted living have burned through all of their equity. They are taken off the waiting list. These people will eventually end up as a burden to the state of California. They will require Medi-Cal for their housing.
Thank you very much.
Nursing homes. So I urge an aye vote for SB 660.
Thank you. Next witness in support.
No, she's my staff.
Okay, very good. Well, she could also testify, and no one would have known the difference. Any other witnesses who wish to testify in support? Seeing none, witnesses in opposition? Welcome. First witness in opposition, please.
My name is Gene Urban. I represent the Bank of America. I'll try to be brief and concise. We are opposed to the imposition of the duty of good faith, honesty, and fair dealing, absent the amendment that we've offered, which would create a rebuttable.
Yeah, speak.
We're opposed to the imposition of the duty of good faith, honesty, and fair dealing, absent the compromise we proposed, which would create a rebuttable presumption. If we meet the requirements, prescriptions, restrictions, limitations, disclosure requirements in the chapter, that would create a rebuttable presumption that we've discharged the statutory duty, no other duty, including that implied by common law in every contract, and it would then be incumbent upon the plaintiff to produce some quantum of evidence about how we violated the duty. I think, as I've testified in previous committees, it's pretty simple. This is all about the damages to which the plaintiff may be entitled. Under the implied covenant of good faith and fair dealing, there's little opportunity to pursue tort damages. It's been limited. I don't disagree with the analysis in the by the committee counsel. It's been limited to the special relationship in the insurer area as it relates to claims handling. But I believe this lays the statutory groundwork for the creation of a special relationship through statute, not through common law. And if that's the intent, if the intent is to be able to pursue tort damages in a very routine, not unimportant, but routine commercial transactions, we have to oppose the bill, absent the compromise that we offered in good faith. Thank you.
Thank you, Mr. Urban. Next witness in opposition, excuse me.
Mr. Chair and members, Scott Govan on behalf of California Financial Services Association. Certainly we concur with Mr. Urban's testimony. We offered amendments and pointed out this issue to the author and proponents months ago. Those were rejected. We do think the intent of the bill is to increase liability, and the amendments were an effort to try and mitigate that. We're not objecting to being honest, good faith, and fair dealing, but we do want some legal protection, which the recent amendments, which we were not a party to, provide none. So for these reasons, we are opposed.
Thank you very much. Are other witnesses in opposition?
Mr. Chair and members of the committee, Kevin Gould with California Bankers Association, also in opposition for the reasons stated. Also would just like to briefly acknowledge...
Thank you. We're going to be limiting to 2 witnesses on each side. Please, next witness in
Mr. Chair,
opposition.
committee members, my name is Pat Zenzala. I'm here on behalf of the California Mortgage Bankers Association. We're also here in opposition to the bill.
Thank you. Others in opposition?
Robert Callahan with the California Chamber of Commerce, also here in opposition. Thanks.
Thank you.
Dawn Kepke with McHugh & Associates on behalf of the California Credit Union League, also in opposition.
Thank you. Are there any other witnesses in opposition? Seeing none, members of the committee, questions or comments? Seeing none, Ms. Woke, the bill has been moved. It's been seconded. Ms. Woke, would you like to close?
Thank you. Once again, I would like to thank the chair and Mr. Clark for their assistance, not only in front of this committee, but as these issues came through the Senate as well. They were, appreciate your advice.
Okay. Thank you, Ms. Woke.
I vote.
Thank you. Please call the roll.
Fear?
Aye.
Fear, aye. Tran? No. Tran, no. Brownlee? Evans? Evans, aye. Chesbro? Chesbro, aye. Knight? Knight, no. De La Torre? Liu? De La Torre, aye. Liu, aye.
Aye.
Monning? Monning, aye. Nilo? Nilo, no.
That bill is out. Congratulations, Ms. Woke.
Thank you, Mr. Chair and members.
Our next author is Senator Leno, item number 1, SB 54. Welcome, Mr. Leno. Please proceed.
Thank you, Mr. Chair. Committee members, thank you for your time today. As I introduce SB 54 to you, let me say that there are probably few who were more disappointed with the passage of Proposition 8 and with the subsequent Supreme Court decision to validate it as constitutional. But the basis on which SB 54 is founded is directly taken from the Supreme Court decision ruling that Prop 8 is constitutional in the court case known as Strauss v. Horton. So what the bill does, very simply, is addresses the uncertainty of the status of those who married out of state. Strauss versus Horton did not specifically address the marriages of same-sex couples who married out of state because no one in that situation was a party in the case, so they could not rule on that. And it leaves many thousands of couples in a very uncertain situation right now. So I'm going to give you an example of a couple. We've got an actual couple who will share with you their tale. But I just want you to really put yourself in the situation of a particular couple, let's say from the state of Iowa, who maybe grew up together, fell in love in high school, subsequently formed a family, raised a number of children, and then once the Supreme Court in Iowa determined that they could get married as a same-sex couple, they did so. And so they now have the opportunity, because of their corporation opening office, let's say in Silicon Valley, opportunity of a lifetime, because they maybe see their salaries doubled as a result of this opportunity that they could take in California, provide a college education for their kids if they didn't think they could do so in Iowa. They take the job in California and they move themselves and their family to Silicon Valley. But now when they arrive here, are they married? They were married legally in Iowa. Are they married here in California? Strauss v. Horton was silent on their situation. So taking the substance and the very words of the decision determining that Prop 8 is constitutional, we believe that it is appropriate for the legislature to clarify this ambiguity and determine that they are in fact married here in California. And I want to, and I don't intend to bore any of you, but I do want to share with you the very words of Strauss v. Horton to show you on what basis we believe SB 54 is very sound. I'm reading from the court decision, the majority opinion. In analyzing the constitutional challenges presently before us, we first explain that the provision added to the California Constitution by Proposition 8, when considered in light of the majority opinion in the marriage cases, that of course was the Supreme Court decision ruling unconstitutional the denial of marriage licenses to same-sex couples, that's the marriage cases. When considered in light of the majority opinion in the marriage cases, properly must be understood as having a considerably narrow scope and more limited effect than suggested by petitioners in the cases before us. Contrary to petitioners' assertion, Proposition 8 does not entirely repeal or abrogate the aspect of a same-sex couple's state constitutional right of privacy and due process that was analyzed in the majority opinion in the marriage cases. That is, the constitutional right of same-sex couples to choose one's life partner and enter with that person into a committed, officially recognized, and protected family relationship that enjoys all of the constitutionally based incidents of marriage. Instead, the marriage carves out the measure, Prop 8, this is the Supreme Court's ruling that substantiated that it was constitutional, is on this basis. Instead, the measure carves out a narrow and limited exception to these state constitutional rights, reserving the official designation of the term marriage for the union of opposite-sex couples as a matter of state constitutional law, but leaving undisturbed all of the other extremely significant substantive aspects of same-sex couples' state constitutional right to establish an officially recognized and protected family relationship and the guarantee of equal protection of the laws. So what they were saying is that, yes, Prop 8 is constitutional, but only with this narrow exception of same-sex couples not being able to be determined married. Now, that is for those who are going to be married after November 4th. We are all well aware that those who married before November 4th, after the marriage decision of May of 2008, those 18,000 couples, we all know, the court ruled are married. So for those who were married out of state prior to November 4th, they come to California. Based on the court's ruling, this bill will clarify that those couples are also legally married in California. How could they be otherwise? And just to read one other...
If you could briefly, Mr. Leno.
I'm sorry?
Briefly, please, Mr.
Very briefly. Very briefly. I'll get to the good parts here. So, in sum, although Prop 8 changes the state constitution as interpreted in the majority opinion in the marriage cases to provide that restricting the family designation of marriage to opposite-sex couples only and withholding that designation from same-sex couples no longer violates the state constitution, in all other respects, same-sex couples retain the same substantive protections embodied in the state constitution, rights of privacy and due process, as those accorded to opposite-sex couples, and the same broad protections under the state equal protection clause that are set forth in the majority opinion in the marriage cases. And then for those out-of-state couples who may marry after November 4th, given, of course, that the exception of equal protection in this ruling is only for the designation of marriage, when those same-sex couples come to California, they will be afforded all the same rights, benefits, privileges, and the obligations and responsibilities of marriage. They will only not be recognized as married, and that is based solely on the reading of the decision. And then I just wanted to bring up very briefly a couple of the oppositional arguments you're going to hear. I've seen in a report today in the news that the California Catholic Conference is concerned on a couple of issues. This is a gut and amend. Let me say that. This is a gut and amend. Why are we doing this now as opposed to earlier in the year? Well, of course, the decision didn't come out until May 16th. That's just 6 weeks ago. So it took us a little while to do some study of this and to put it in a bill form. No, I guarantee you no process will be shortcutted. Should this pass out of the Assembly and make its way back for concurrence in the Senate, quite happy to have this heard in the Judiciary Committee in the Senate. So no shortcut will be taken. They go on to say that that this is unnecessary because these same-sex couples could become domestic partners in California and have all the same rights, benefits of marriage without the designation of it. But what they don't seem to understand, and you'll hear from couples themselves, is when those couples come to California and are married, if it was before November 4th, they could not get married in California because you can't marry a second time when you're already married once. So they would not have that opportunity to get married. And so we just wanted to clarify that as well. So thank you for your hearing us today. We have a couple of our sponsors who wish to speak, and then we have a couple who fit this exact situation to explain their predicament now because of the messy affair that inequality is.
Thank you very much, Senator Leno. Again, a reminder, 2 witnesses on each side. Apportion your witnesses as you'd like.
Move the bill.
Thank you. So our sponsor, Equality California.
Okay. It's been moved and seconded.
Okay. Hi, Mr. Chair and members of the committee. My name is Ilona Turner, and I'm a staff attorney at the National Center for Lesbian Rights in support of SB 54. First, to clarify what the bill does, SB 54 is needed to clarify the court's decisions in marriage cases in Strauss v. Horton so that couples who married in a jurisdiction outside of California prior to November 5th, 2008 will clearly understand that they will continue to be recognized as married in California. And it's also necessary to clarify, following the court's decision in Strauss v. Horton, that couples who married outside of California after the enactment of Prop 8 are entitled, and the California Constitution requires that they receive full equality under the law, including all the substantive rights and responsibilities of marriage other than the word marriage, which Proposition 8 reserves. This bill is of great practical importance for numerous same-sex couples in our state. Ever since Proposition 8 passed, we've been getting calls from couples all over California who are experiencing a great deal of anxiety and confusion about what their legal rights are. No family should be left with that kind of uncertainty about what legal protections their family is entitled to, trying to figure out whether they even have any legal rights in the state or if they're now considered legal strangers. SB 54 is a sound approach to clarify this confusing situation, which is squarely in line with and indeed mandated by the holdings of the California Supreme Court in the marriage cases and Strauss v. Horton. We've consulted with the leading family law scholars and experts in the state who all agree that this bill clarifies the rights of couples who married outside of the state in a way that's plainly required by existing California law and precedent. The discriminatory effect of Proposition 8, which took away the right to marry from same-sex couples, inflicts serious harm on LGBT families throughout the state. But the confusion over the rights accorded to marriages from outside the state is one of the harmful effects that the legislature can and should address right now. We strongly urge the committee to vote yes on SB 54 to provide this important clarification and peace of mind to same-sex couples and their families who married outside the state.
Thank you very much. Next witness in support.
Good afternoon, Mr. Chairman and members of the committee. My name is Alex Ingersoll, and I'm appearing here with my husband, Martin Tannenbaum. I moved to California in 1979, and Martin moved here from Boston in 2005. We were married in Provincetown, Massachusetts on September 14, 2008. When we met, we were in our 50s, and we each knew immediately that this was the man with whom I wanted to spend the rest of my life. We soon decided that we wanted to publicly declare our love for one another in the presence of friends and family. We wanted to get married. We wanted to have a Jewish wedding and also wanted a civil wedding, one that would be recognized and respected in the eyes of the law. In 2006, when we decided to marry, same-sex couples could not legally marry in California. Massachusetts was an obvious choice. Martin lived in Boston for 30 years. My forebears arrived there in 1629, and I still have family there. Like many couples, we wanted to marry in a place with deep personal meaning to us, our families, and our friends. A few months before our wedding, the California Supreme Court declared same-sex marriages legal in our great state. We thought about getting married in California instead of Massachusetts, but we'd already made extensive plans. To ensure that our marriage would also be recognized in California, we looked into getting a second marriage license in California, but the application itself made it clear that it would not be legal to get married in 2 states. Last September, 65 family members and friends joined us on Cape Cod for a weekend of celebration, culminating in our wedding. Our rabbi first performed a civil ceremony with all the vested authority of the Commonwealth of Massachusetts. Then our families walked us down the aisle, and under HOPA,
if you could please conclude your testimony.
Okay. We returned to California with a strong belief that our state recognized us as a married couple. This was 2 months before the vote on Prop 8. We were deeply disappointed, but still believed we were still married. Hence we filed as a married couple.
Okay. Last sentence, please.
I just want to say, imagine if you were married in front of your closest friends and family, shared the joy with your neighbors, congregation, and co-workers, and then were suddenly told your marriage may not be considered valid. Imagine how that would feel. For this reason, we urge you to support this bill, assuring us and our families of the civil legitimacy of our marriage. Thank you.
Thank you very much for your testimony. Other witnesses in support?
Alice Kessler with Equality California. We're the sponsor. Urge your I vote.
Next witness in support.
Mr. Chairman, members, Helene Meshar representing the City of West Hollywood, and I wanted to convey to you today that this item is on the City Council agenda for Monday to support it, but wanted to convey it to you today.
Thank you very much. Others in support?
Mr. Chairman and members, Francisco Lobaco on behalf of the American Civil Liberties Union in support, and I say I appreciate the consultant's very scholarly analysis of the bill. Thank you.
Thank you.
Erin DePay with Planned Parenthood Affiliates of California, also in support.
Thank you. Other witnesses in support? Are the witnesses here in opposition? Welcome, please. Sir.
Thank you, Mr. Chairman and members of the committee. Ben Lopez, representing Traditional Values Coalition. Clarification on the time. 2 minutes, or do I get the full 4?
No, 2 minutes.
That I try.
Good try.
Drew warned me about that in the hallway.
I'll start your time now.
Thank you. Like Mr. Leno said, he wanted you all to get a firsthand appeal of a person who's lived in these people's shoes. I'd like for you to put yourself in the shoes of millions of Californians who passed Prop 8 and over 7 million who passed 7 million who passed Prop 8 and millions who passed Prop 22 in the past. What this is a concerted effort yet again to somehow incrementally get gay marriage by any means possible and overturn Prop 8, 22, and now the court's ruling. And where will it stop? The court ruling upheld Prop 8. It did 3 things. It upheld the 18,000 gay marriages, it upheld Prop 8, and it upheld the current domestic partnership program. Didn't even touch it. All rights of marriage could be entered into through a domestic partnership program in the state of California. You know, the author made the argument when we were discussing Prop 22 that Prop 22 only applied to in-state marriages. It didn't affect those outside the state. Well, I think the roles now is being reversed because this is an attempt to stretch the court's ruling to somehow say that the court was not wise enough to give itself its own clarification. Therefore, the legislature in its infinite wisdom must clarify what the court said, and therefore we need this bill to say out-of-state marriages should be legal here too. Bear in mind, though, that at a time Prop 22 was in effect, certain states did have gay marriage, and if that were the case, they could still not be valid because of Prop 22 still being in effect before it was struck down. And the only time frame, if you will, in which marriages should technically be legal were from the time that the Supreme Court struck it down in May 2008 to the time Prop 8 passed. If those marriages happen in that time frame, I suppose if they move in, they're valid. But to say that any marriages under the sun, regardless of the time sunsets, if you will, or the time frames and the restrictions that we place, the voters place from 22 and any other ruling, should be thrown out the window is absurd. And
Thank
for
you.
that, I request your no vote on the bill.
Thank you for your testimony. Other witnesses in opposition? Seeing none, it's been moved and seconded. Do members of the committee wish to make comments or ask questions? Mr. Delatorre, and then Mr. Liu.
I appreciate the timing and the Prop 8 and not Prop 8 and the window and the closed window and et cetera, et cetera, et cetera. The bottom line is this. You have people who got married. They got married legally, and they live in the state of California. They got legally married somewhere else, but they live in the state of California. The whole point of our federalist system is that if you do something in one place, it counts everywhere else. And so you come to California, you're married, then we need to recognize it. Just like the court acknowledged the marriages that took place in that window in the state of California. That's the fundamental thing that we are dealing with here. We're not dealing about hypotheticals. We're not dealing about legal theories. We're dealing with people who actually got married, who have a marriage certificate, and who live in the state of California, period. And so that's why I'm supporting this measure.
Thank you, Mr. Delatorre. Mr. Liu.
Thank you, Senator Leno, for bringing this bill. I'd like to be added as a co-author.
Thank you, Mr. Liu.
Thank you.
Thank you. Mr. Knight and Mr. Chesborough.
Well, I suppose I have to speak on this. You know, the way I look at this is not just a same-sex issue bill that we have before us. And I'm not going to go into what the will of the voters is and what has been said over the last 10 years and all of that. I believe that states do, by the Constitution, have the right to make their own laws and be able to do as they see fit for the livelihood of their citizens, so that states can make their own laws that are not transversed over to another state. Just like there are gun laws in other states that we do not accept, just like there are registration laws with cars that we do not accept. When you come to California, you have to abide by California laws. Now, I am not one of the attorneys up here, so I'm not going to go into the case, the Strauss v. Horton. But I am going to say that when a law is produced in this legislature, and when a law that is so contentious as this has been over the last 10 years, the people have spoken on this issue several times. They have come forward. This bill is fairly obvious that we are going to try and use the legislature to undermine what they have said. We are going to try and change their will. And that is not fair, because they're going to start reading this in the papers over the next week. And they're going to be very upset that this was sent through very quickly and without any opinion from them. And the big bad legislature is going to do what they want to do on an issue that has been so spoken about over the last 10 years. And the fact that it is illegal in this state, and again, just because this is a same-sex issue shouldn't make it any different. It is illegal in this state. The fact that we would allow people to come from another state where it's legal and bring it here and now determine that we're going to say it's legal is not fair. And it's not fair for many issues that we don't have that same compatibility with other states.
Thank you, Mr. I do want to point out before turning to Mr. Chesborough that this is a situation in which the California Supreme Court, interpreting our Constitution, has in fact validated numerous same-sex marriages and opined further on the incidence of marriage to which Mr. Leno referred in his opening statement. Mr. Chesborough.
Yes, thank you, Mr. Chairman. We had a very moving ceremony recognizing July 4th last week on the floor. in which it was spoken at length about how we've fallen short of the great dream of our Constitution and our Bill of Rights down through our history, but that it's been an ever-expanding rising to offer full equality to all individual human beings. If the argument, and I'm extrapolating admittedly, of the witness in opposition is that somehow this is part of the full unfolding of our acknowledgement of the full humanity of all citizens of our state and our country, then I associate myself very strongly with that, and would like to ask to be added as a co-author as well, even though I understand that it's a specific legal fix to a problem. I do think it's part of that larger unfolding. It's not enough. It doesn't go far enough. We are constrained by the actions of the voters, but I'm very pleased that we're looking to find every way to offer full equality to every citizen of our state.
Thank you. Other members of the committee?
If I may clarify, Mr.
Tran and Ms. Brownlee.
Very, very briefly, I understand the intent of the bill and the legislation, but federal law, DOMA, Defense of Marriage Act, in fact, does not provide for full faith and credit, or the doctrine of comity, which address what Mr. Delatorre is talking about, and which also touches on what Mr. Knight says, which basically means that the state Supreme Court left this issue open and silent. And I think because of the nature of the issue, which is so fundamental, and it involves people's philosophy and convictions and beliefs, I think the people of California have spoken at least twice on this issue. If we are going to fully vet this issue again, if there is an unsettled matter such as this, out-of-state couples getting married before the November deadline or whatever, then we should bring that back to the people of California. But to try to legislatively circumvent this or short-circuit this whole process without the participation of the people on such a fundamental issue, I'm afraid that I can't support it at all.
Thank you, Mr. Tran. Ms. Brownlee.
Yes, I just wanted to say that I think it's absolutely the legislative role to clarify this issue for people who will come to our state. And I certainly believe that this is the right thing to do, and it's the humane thing to do. And in honoring humanity, I think that's the fair thing to do. It was said earlier that this is not fair, and so I just want to say that I believe that it is fair and would be honored if I could also join you in being a co-author to the bill.
Thank you very much.
Thanks.
Thank you, Ms. Brownlee. Other members of the committee wish to offer a question or a comment? I'm going to say a couple things. Mr. Leno said something at the inception of his remarks that's very true. Inequality is messy business. This legislation, on my view, attempts in a limited way to clarify an issue that could result in exacerbating inequality. In response to a couple of remarks that were made in opposition to the bill, our situation in California is somewhat different from elsewhere because we had a very limited window in which marriage was lawful for same-sex couples. And then we said it was okay, and then very shortly thereafter said it was not okay anymore. No other state has had that experience. This bill, in my view, is utterly consistent with the Supreme Court's ruling in Strauss in two ways. First, it recognizes pre-Proposition 8 same-sex marriages as valid, as did the court in Strauss. Even the dissent, was the dissent in the marriage cases, even Mr. Baxter, for example, who was a dissenter in the marriage cases, was in fact at the oral argument among the key proponents of saying, we ought to at least validate those marriages that took place already. We can't retroactively invalidate those. It's also consistent with Strauss in another respect, in that it gives legal recognition but doesn't call that marriage to, in fact, valid marriages from elsewhere. So this pretty much tracks what the Supreme Court did in its opinion validating Prop 8. pre-November, marriage valid. Post-November, you have a relationship. It has all the incidents of marriage. But we're not going to call it that. That's what Mr. Leno's measure does. And with regard to the Federal Defense of Marriage Act, you know, that act does not require a state to invalidate or not recognize marriages from elsewhere. It gives states discretion as to how they wish to proceed. This legislation enables us to exercise that discretion one way or the other. You can argue that we ought not exercise it in the direction that Mr. Leno proposes, but that's not to say that we're precluded from doing so. In fact, DOMA invites us to do just the opposite and endorse Mr. Leno's measure. Is this in some manner contrary to the will of the people? Well, you know, the Constitution is the ultimate expression of the people's will in the state of California. The court in Strauss interpreted the Constitution in a manner consistent with this measure. Ultimately, I think we need to listen carefully to what our Constitution says as we listen carefully to what voters say. And I would urge an aye vote. Mr. Leno, do you wish to close?
Just very briefly, I thank you for all the supportive comments and for your very articulate assessment of the situation, Chairman Pure, and also to thank your staff for a very finely written analysis which traces the history of the issue as well as what Strauss actually said. And the comment is made that this undermines the decision is completely inaccurate. As I said, I was completely disappointed by the decision that upheld Prop 8, but it was upheld on a very specific understanding that no rights, benefits, privileges, obligations, or responsibility of marriage would be denied any couple after November 4th that they had prior to November 4th. I was in the courtroom listening to the Chief Justice in the oral arguments ask the City Attorney of San Francisco, tell me, City Attorney, what rights and benefits have been lost after November 4th that existed prior to November 4th. We have a domestic partner registry in California that allows for all of them. Not quite accurate, but nearly so. And so he said the only thing that is lost after the fact of the passage of Prop 8 is the word marriage. Now, it was a flip-flop argument from what they made in the marriage cases of the year before, but nonetheless, they upheld Prop 8 because they said they were carving out a very narrow exception to the Equal Protection Clause, and the only thing that was lost to same-sex couples was the designation of marriage. So we have couples, California couples, law-abiding, tax-paying California couples who were married out of state because they couldn't marry here. And when they came back from their marriage, they could not get married again for the reasons they described. What are we to do with these couples? And so many of them have children and families that need legal protection, just like everyone else. So just in closing, I would say that as our president reminds us in word as in fact every day, change has come to America. And I want to point out that one of the visionaries of that change coming to America was Senator Pete Knight. He saw the winds of change blowing strongly and wanted to hold on to the status quo, and that was the reason for Prop 22. He could see that the change was about to hit California, and he wanted to protect the status quo, the discriminatory status quo. And that was what Prop 22 was, and it passed 61 to 39. In a short 8 years, Prop 8 has shown us that 22 points in support of discrimination has now been reduced to 4. Change has come to America, and marriage equality will be the law of the land in California very quickly, as it is happening in states across this nation at a rate no one could have imagined. We're at 6 now, we'll be at 7 very soon, it could be 8. It will not be long till we have it here in California as well. In the meantime, we have the fact of thousands of couples legally married in this country who live in California, raise their families, go to work, pay their taxes, abide by the laws. It not only would be inconsistent with the decision of Strauss, as it would be heartless not to recognize them if they were married prior to November 4th, as yet married, and if they were married after November 4th, everything afforded them as opposite-sex couples short of the word marriage. And that is the wording directly taken from Strauss. I would ask for your aye vote.
Thank you very much, Mr. Leno. And if you would add me as a co-author as well, call the roll, please.
Be honored. Thank you.
Fear?
Aye.
Fear, aye. Tran? Tran, no. Brownlee? Brownlee, aye. Evans? Evans, aye. Chesbro?
Aye.
Chesbro, aye. Knight? Knight, no. De La Torre? De La Torre, aye. Liu?
Aye.
Liu, aye. Monning?
Aye.
Monning, aye. Nilo? Nilo, no.
Okay. Thank you very much. Congratulations, Mr. Leno. That bill is out. Now, Mr. Wright is here on SB 156. As Mr. Wright is coming to the dais, if we could please have a motion on the consent calendar. Is there a second? Call the roll, please.
Fear?
Aye.
Fear, aye. Tran? Tran, aye. Brownlee? Brownlee, aye. Evans? Evans, aye. Chesbro?
Aye.
Chesbro, aye. Knight? Knight, aye. De La Torre? De La Torre, aye. Liu? Monning?
Aye.
Monning, aye. Nilo? Nilo, aye.
The consent calendar is approved. Welcome, Mr. Wright. You're here on number 3, SB 156.
Thank you, Mr. Chair. Members, this bill has no opposition. In short, what it does, it extends an effort that I started a number of years ago to try to reduce insurance fraud. This allows insurance companies in the presence of law enforcement to get together to compare trends and other issues so that they're able to reduce the fraud. We took some amendments that removed the opposition of the consumer attorneys. I have witnesses here in support, and I'm not. Don't everybody speak at once. But again, it is a narrow measure that attempts to reduce insurance fraud. You in this committee are certainly aware of the cost of insurance fraud in California. So I'm going to ask Mr. Gunning here if he would start.
Very good. Mr. Gunning, you're welcome.
Chairman Michael Gunning, Personal Insurance Federation, here in support of SB 156. As you've seen in the bill, insurance fraud is a costly measure that I suspect a lot of Californians don't understand the impact it has. Lots of times individual companies working on their own trying to prevent fraud don't get a chance to compare notes. So as one of the recommendations from the commissioner was, let's get an opportunity to sit in a room and try to at least look for trends and track issues or potential fraud rings that we can stop. One of the hassles there, of course, was the liability that comes with that, and certainly appreciate the committee and Drew's effort to hammer that out, and we're here in support and urge an aye vote. Thank you.
Thank you, Mr. Gunning. Next witness in support, please.
Good afternoon, Mr. Chair, members of the committee. Laura Alarcon on behalf of the California Department of Insurance. Information sharing is a vital tool in the efforts to combat insurance fraud. This bill will provide the clarification and the needed checks and balances to promote the needed information sharing that needs to occur between the insurers and the Department of Insurance. For that reason, the Department is in full support of this bill and urges your aye vote. Thank you.
Thank you for your testimony. Next witness in support.
Rick Pline, also with the Department of Insurance, urging an aye vote.
Okay, so we're really sure the department supports the bill. This is good.
On the technical.
Oh, fair enough. Thank you. Are there other witnesses here in support of the measure? Is there any witness here in opposition to the measure? Seeing none, committee members, questions or comments on this bill? Seeing none, it has been moved. Is there a second? Second. Mr. Wright, do you wish to close?
And ask for an aye vote.
Thank you, Senator. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran?
Aye.
Tran, aye. Brownlee? Sorry. Brownlee, aye. Evans? Evans, aye. Chesbro? Aye. Chesbro, aye. Knight? Knight, aye. De La Torre? De La Torre, aye. Liu? Monning? Aye. Monning, aye. Nilo? Nilo, aye.
Congratulations, Mr. Wright. That bill is out.
Thank you.
Okay, we have 2 items left on our agenda. The next is item number 2, SB 94 by Senator Calderon. Senator Calderon, welcome.
Thank you, Mr. Chairman, and thank you for the opportunity to present this loan modification consultant reform measure. Members, I'd like to begin by offering all of the amendments that are noted on page 9 of your committee analysis.
Thank you.
Appreciate your work and your staff's work on that. SB 94 will crack down on a growing problem in California. That's the practice of loan modification consultants that are charging borrowers very high upfront fees and then failing to help the borrower. Now, under the provisions of this bill, no one, and it's very clear, no one, not a real estate broker, a lawyer, no one will be able to charge a borrower upfront for loan modification services. Anyone who wants to charge a borrower for loan modification services after performing them must first give the borrower a notice informing them that similar services are available free of charge. Borrowers need to understand that they don't have to pay to get help modifying their loans. Now, SB 94 is supported by several consumer groups and housing counseling agencies, the San Francisco and Los Angeles DA, the City of Oakland, the State Bar, and the California Association of Mortgage Brokers, and AFSCME. These organizations see the negative effects of the loan modification consultants on a very daily basis, believe that SB 94 will provide needed protections for borrowers. With this, I ask for your support, your aye vote.
Thank you very much, Senator. First witness in support.
Good afternoon. Anthony Williams with the Waddle Williams Law Group. On behalf of the State Bar of California, we are in strong support of this bill, particularly the fact that it applies to attorneys and makes clear that accepting advance fees for loan modification work is a violation of the rules of professional conduct and subjecting attorneys to discipline. The State Bar has been, for lack of a better way to put it, and to be blunt, inundated with complaints and calls regarding loan modification abuse. We're investigating over 100 attorneys suspected of defrauding thousands of consumers. This bill, we think, balances the need to have access to legal services with the need to also prevent fraud and have a preventative effect. And we think that this bill does that, and we strongly support the bill for those reasons. Thank you.
Thank you for your testimony. Next one is in support.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. We know that when families are at risk of losing their homes, they are desperate to believe that their homes can be saved, and they're pretty much willing to agree to just about any terms if that person promises that they can deliver. And so we are increasingly hearing from our members and from workers across the state that they are falling victims to these type of foreclosure scams. That's why we believe this is an important protection, and we are here in support. Thank you.
Thank you for your testimony. Next one is in support.
My name is Paul Leonard. I'm the California Director of the Center for Responsible Lending. We strongly support this measure, which represents a balanced approach to...
Thank you very much. Others in support?
Jim DeBoo on behalf of the City of Los Angeles in support.
Thank you. Other witnesses in support?
Tom Poole, the California Department of Real Estate. We are neutral on the bill. I just want to point out a couple of things. To build on what the State Bar was saying is that we have seen a huge number of cases involving loan modification scams. To put this in perspective, last June we had less than 10. Currently we have over 800. The number continues to grow. So I think this bill does address a very important issue that the Californians are facing, especially financially stressed borrowers. There's a couple things in the analysis I want to point out. The analysis indicates that there's a 2-year sunset on this. In fact, it's 3. If there's an urgency clause added to this, this bill would be in effect for approximately 2.5 or 3.5 years.
And there is an urgency clause pending on the bill.
Yes. So I think that's important to note. The other thing that the analysis mentions is that the sunset provision in here was supported by the governor. In fact, that's something that the Department of Real Estate wanted in. So I just want to make that clarification.
Thank you for the clarification. Are there other witnesses here in support or, in this case, ambiguous about where they stand?
Yes, thank you.
All right. Now, with regard to opposition, is there any witness who wishes to testify in opposition to the measure? Seeing none, are there questions or comments from committee members?
I have one question.
Okay, Mr. Liu and then Mr. Tran, please.
Thank you, Senator Calderon, for bringing this bill. I'd like to be added as a co-author.
Thank you.
Thank you. Mr. Tran.
Okay, this bill, once again, good morning. This bill was heard in banking and finance, and if I may continue the running dialogue that we had in terms of the question, because I did vote against it, and I spoke with you regarding at least administrative costs be fronted by the homeowner. so that there should be some equity and fairness on the part of the service that's being provided. Administrative costs, clerical costs. Basically, this is a blanket prohibition on any and all advance fees. And as one of the gentlemen said, you have isolated incidents of fraud or misrepresentation out of hundreds, if not thousands, of loan modifications. At least there ought to be some balance here in terms of some costs being recouped by the businesses.
Certainly. Wouldn't expect anybody to do anything for free. The service provider can collect administrative costs within the contract. They can include whatever that administrative cost may be, and that the customer or consumer and that service contract for. But that would be after the services are provided. So there's no restriction in this legislation that it would allow the collection of administrative costs.
I think my concern is the costs will be incurred whether the negotiations or the modification is satisfied or not. You still have to use the phone. You still have to turn on the electricity and all the clerical costs. That's where it is.
And again, this legislation does not limit the amount of money that can be collected after the services are provided.
All right. Thank you.
Thank you, Mr. Tran. Other members of the committee with comments or questions on the bill? Seeing done, it's been moved. Is the bill seconded? It's been moved and seconded. Senator Calderon, do you wish to close?
Ask for your aye vote.
Thank you very much. Call the roll.
Fear?
Aye.
Fear, aye. Tran? No. Tran, no. Brownlee? Brownlee, aye. Evans? Evans, aye. Chesbro? Chesbro, aye. Knight? Knight, no. De La Torre? De La Torre, aye. Liu? Liu, aye. Monning? Monning, aye. Nilo? Nilo, aye.
Congratulations, Mr. Calderon. That bill is out.
Thank you very much.
Okay, our last item today is item number 4 on our agenda, SB 392 by Senate Majority Leader Flores. Senator Flores, welcome.
Thank you. Thank you, Mr. Chair. This measure, SB 392, authorizes the issuance of contractor's license to limited liability companies. It also requires LLCs to maintain specific amounts of liability protection consistent with existing law. And we would like to propose author amendments to address some recent concerns. These amendments would allow the employee of an LLC to recover unpaid wages, interest on wages, fringe benefits, and will also cover welfare, pension, and apprenticeship fund contributions in the case of a collective bargaining agreement. The bill has moved through the Senate and the Assembly with no votes, and we would respectfully ask for your aye vote.
Thank you very much, Senator. First witness in support, please.
Mr. Chairman, members, my name is Paul Gladfelty. I represent the Associated General Contractors. We're the sponsors of the bill. This was brought to us by one of our members. First and foremost, the purpose of the bill is not primarily for liability purposes. We do have subchapter S corporations. We have C corporations. If we wanted to shield liability, they could certainly be formed as one of those corporations. The consultant has done an excellent job of outlining on page 4 the tax reasons, estate planning reasons for having an LLC. And that is principally why we wanted to propose an LLC for California. The LLC status has not been in California too long, but it has been in effect for 14 years, thereabouts. And in the 29 other states, or 29 states in which we have a contractor's license law, California is the only one that does not allow for the LLC existence. And so for those reasons, we have come to the legislature, asked Senator Flores to introduce the bill. We feel it's an important issue for the contracting community. We've worked with the California Trial Bar. We've included a liability requirement of $1 million. We have had several discussions with organized labor. Their opposition was somewhat late, and we've attempted to address their concerns by having a a welfare and wage bond in the amount of $25,000 specifically to cover that. And one other point with regard to covering wages. Under current law, you have the contractor's license bond, which covers wages up to $4,000, wages and fringe benefits. The maximum amount of that bond is $12,500. So essentially the bond that we're proposing would be about 5 times more than what is currently required.
Thank you, Mr. Gladfelty. Others in support?
Mr. Chair, Phil Vermeulen, representing the engineering contractors and several other contractor associations, strong support. I also would add that I also represent American Contractors Indemnity, which is the largest surety bond company in the state for contractor bonds. They've gone back through and checked their records, and they say that wage claims are very few and far between. We believe strongly that the $25,000 bond offered today makes a lot of sense, and we would urge that you accept the amendments and also vote aye on the bill today. Thank you.
Thank you very much for your testimony. Others in support?
Yes, Mr. Chairman, Kevin Pedrati, representing the Engineering and Utility Contractors Association, in support.
Thank you. Others in support?
Good afternoon, Mr. Chairman. Park Terry, representing the 3,000-member California Landscape Contractors Association. Both large and small contractors were strongly in support of this bill.
Thank you. Others in support?
Thank you, Mr. Chair. Todd Blumstein on behalf of the Southern California Contractors Association, in support.
Thank you. Other witnesses in support of this measure? All right, seeing none. Witnesses in opposition? Welcome. First witness in opposition, please.
Mr. Chair, members, Jay Hansen with the State Building Construction Trades Council. Regretfully, we must oppose this bill. First, we haven't seen the amendments and would certainly be willing to work with the author, hopefully in the interim, to try to come up with a piece of legislation that works and addresses the concerns that we have. You know, there are over 300,000 active contractors' licenses today. You know, they've been operating up to now without any issues, so we're a bit mystified for the need of the bill of, you know, such an expedited and rushed manner. We believe that we have trouble collecting the wages that are owed and benefits from corporations enough as it is, and allowing LLCs to be part of this contractor game is just going to expand the problem and make it a little bit more difficult. The contractor community is conflicted. You'll see that the folks that are supporting the legislation are the non-union contractor community. The unionized contractor community is not in support of this. Changing the law to allow out-of-state contractors to work here in California isn't really much of a motivator for many of the folks that are in the business. And offering a $25,000 bond is clearly insufficient. You know, that could be just a couple workers working for a few weeks could earn enough money to reach that level. Pension payments for union contractors are typically paid on a monthly basis. For the non-union, it's once a year, typically 3 or 4 months at the close of the year. So a huge amount of money could certainly be racked up for a contractor that didn't want to play by the rules. We don't believe that's why the author is doing this at all. We don't believe that's what the sponsors are doing. In fact, we work with both many more times than not. So it you know, is a bit of a pain for us to not be working together, because that's traditionally what we do. You know, we strongly believe that we should look at fixing the problem that we already have with the extreme difficulties piercing the veil and holding corporations accountable for owed wages, including pension and health care. You know, we need to fix the bonding amounts for corporations instead of exasperating the problems and adding LLCs as another form to doing this. I'd like to introduce our attorney, Scott Cronland, who's here, and he represents many different unions within the building trades and unionized industry.
Thank you.
As specific information.
Next witness in opposition.
Thank you, Mr. Chair. I'm Scott Cronland from Altshuler-Burzon, representing the State Building Trades Council. We're concerned that this is going to exacerbate the problem of contractors that go out of business, leaving workers, pension funds, or tort victims holding the bag. It's extremely easy to form an LLC. There's essentially no downside to it as there is with a C corporation or S corporation in terms of restrictions. So if this passes, we're concerned that there's going to be an explosion of contractors organizing into the LLC form. We already have a problem with contractors in the corporate form going bankrupt, owing money. I understand that efforts have been made to try to deal with the problem, but they still need work. One effort is to require liability insurance be posted to protect tort victims. The amount of insurance, though, is based on the number of persons of record of the LLC in the bill, which doesn't really make sense. It was copied from the provisions regarding LLPs, like law firms, that are limited liability partnerships where the amount of malpractice you need is based on the number of partners. As you get bigger, it makes sense that you need more malpractice insurance, but the number of persons of record of an LLC doesn't really have anything to do with the size of the LLC. You could have one person of record, huge amount of business, or many persons of record, not that much business. And then the wage bond, anyone who's handled claims from employees or pension funds or unions knows that $25,000 is a tiny fraction of the amount of liability that can be run up if you are paying people under the table, if you're shaving hours, if you're not paying prevailing wages, if you're not making the proper pension contributions. When lawsuits are brought, the amount at stake is very, very far in excess of $25,000, and the place to look is not the surety companies, which post relatively small bonds, but bankruptcy courts, where this is happening all the time, where there are large wage claims that are being discharged when companies file for bankruptcy.
Thank you.
Thank you very much, Mr.
Thank
Chair.
you. Other witnesses in opposition?
Mr. Chairman and members, Duncan McFetridge representing the State Pipe Trades Council, State Association of Electrical Workers, and the Western States Council of Sheet Metal Workers. Regretfully in opposition, we look forward to working with the author to address concerns raised.
Other witnesses in opposition?
Mr. Chair, members of the committee, Jeremy Smith on behalf of the California Labor Federation, also in opposition.
Okay. Are there others who wish to testify in opposition to the measure? Seeing none. I'll have some observations. Oh, the bill's been moved. Is there a second? The bill's been moved and seconded. I have Mr. Tran has a question. I will have some questions and observations. Others may as well. Mr. Tran.
I hear the concerns on the part of the opponents regarding LLCs and lack of bonding. There are at least, to my knowledge, 29 states that provide for LLC designation for contractors. Can the author or the proponents tell us how are they doing in terms of whether there's an increase in litigation or a lack of funding, if there's or reimbursements, if there are companies going out of business and things like that? Some of the fears that the opponents are raising.
Thank you for the question, Mr. Tran. Yeah, that is correct. There are 29 other states in which have that are licensing provision states, 28 of which have LLP status. I'm not aware of any specific issues surrounding LLCs in any of those states, and I'm just not aware of any problems. They've been in existence for many, many years, including large industrial states like New York and others.
Thank you, Mr. Tran. Other members of the committee who have questions or observations? Well, Mr. Money, please.
Just a question of the author in terms of the discussion of the amendments. When did that conversation begin?
In terms of understanding the specifics of
it seems like there's some that you've offered an amendment on the bond of $25,000, and there's been opposition expressed to that not being sufficient given the quantities that are often in dispute when there's under the table payments, not payment to pension funds, et cetera, et cetera. I'd just be curious about your response to how you arrived at the $25,000 figure, and are you open to why did you pick that as a ceiling?
And I'll answer the latter part of your question after.
The $25,000 is double the current license bond. License bond is $12,500. We thought that would be a sufficient place to start. And that's how we arrived at that number.
And in terms of the other specifics that we are absolutely committed to engaging with, we would love to continue to have discussions on this. First time I've ever heard any of the specifics from the attorney representing. We're jotting notes down as we spoke because, as I said, this is not a new bill. This bill moved through the Senate through a couple policy hearings, through the entire floor with no votes. And so this is somewhat of a new nuance in the sense that the attorneys laid out 3 or 4 items, and our consultant hasn't met with the attorney who is helping to write the bill either. So I think if we could work on this, Mr. Chair, during the interim, I think we could obviously come up with a very viable solution. I do know that, at least in our side of the world, the Senate, and Mr. Fuhrer knows this, being on the Assembly side, that there will be bills that somehow will be heard after we get back, even though we may have missed a few deadlines. I think we'd be fooling ourselves to think that isn't going to occur. I think this is one of those bills as a candidate that we would like to see heard, given that we could very much reach closure. We wouldn't have to wait to January. We could work through the interim. I'm confident we're going to have a budget. And if we don't have a budget, we have plenty of time here to work through all the way till August to have some sort of requisite agreement so that the bill could continue to move and hopefully be signed and implemented by the governor on January 1st of this year, rather than begin the discussion on something we would agree with in the interim nonetheless. So, I would ask that, obviously the committee will hold the bill, but I will tell you that is something that we will ask to have some agreement on well prior to us taking bills up, all your bills up in the Senate the last 3 weeks, because we will ask the courtesy of this assembly, and you will ask us the courtesy, and we will ask you the courtesy to have this bill heard if indeed any assembly bills are heard in those last few weeks. If there are agreements and we want to proceed through some of the deadline issues. So that would be my only request. And I think we just said earlier that we have been on the same side. It really will take an earnest negotiation. The attorney seems to be very clear where he would like to go, and we would like to, now we've just heard some of these things, move in a direction that would try to get us there. But to somehow wait till the end of the year and to do this again at the start of the year is probably not our wish, and we would only hope that the committee and the chair would allow us the opportunity in the next 30 days to see how close we can get. And I would also ask that the chair and his staff monitor those discussions, and that there be an opportunity to see if it really is ready by the time the end of this session occurs. So that would be my only comment to your last part of your question, Mr. Monning, and that is, we would have absolutely tried to work all of this out if we had known more of this in the Senate. There's no doubt. Things don't get off the floor unanimously very often in our place. So I think to somehow now in the last 3 weeks put this measure away till January wouldn't give us the types of discussion we would probably get done in the next 30 days. And that would be my only request to the chair. The chair can hold the bill till January if indeed we do not reach that, but if we do and can reach a resolution, and if indeed we are going to hear assembly bills without reference to deadlines in the last 2 weeks, somehow I have a feeling we will, we would like the assembly to give us the courtesy as well of hearing this bill and getting it through the process.
Thank you, Senator. I appreciate the clarification.
Thank you, Mr. Monning. Other questions or comments from members of the committee? All right. Seeing none, I'm going to make a couple observations. First of all, Senator, it's clear to me that you have no intention of moving forward a bill that didn't protect workers. That was not your goal in this. The dialogue has been productive here in the committee today. I, as you mentioned and as we've discussed, would like to have the bill held in committee so that we can have ideally very constructive conversations, and I would do everything in my power to direct the parties to engage in those conversations, because If this is to be a change in corporate form that's permissible for contractors, we all, I think, agree that that change cannot take place at the expense of important worker protections. There has to be a balance struck here because there are clear advantages from tax and other standpoints to contractors, and those advantages may be beneficial, but they can't come at a cost to our workers. Having said that, everybody needs to be engaging in good faith discussions about the protection, be it a level of bond, some other approach to assuring that there is a sum of money available in the event of some breach of important laws pertaining to worker rights. Having said that, Senator, with regard to your request, I don't have authority over what happens with regard to rule waivers and when bills are heard and such, but I'm clearly open to holding the bill, having the discussion, and if circumstances arise under which we can hear the bill, if there is a constructive resolution, so be it. I would point out that, as you know, the bill doesn't take effect at the earliest until January 1, 2011. So we have an opportunity now to get ahead of the game if there can be constructive discussions held. If that can happen, so be it. So with due respect to the maker of the motion and the seconder of the motion, given this dialogue, I'd request that we hold the bill pending these discussions and look forward to a positive result. Do the maker of the motion or the seconder have an objection to that?
I don't know why I move a bill, but no, I don't.
Okay. Thank you. Yes, I think if we could have that be as a matter of unanimous consent, given the author's interest in having the good discussions continue. Okay. Thank you. Okay, if so, that'll be the order. Thank you all very much. Seeing no further business before the committee, thank you. The committee stands adjourned.